Hey, good afternoon. This is Richard Hsu. Today I'm host of Hsu Untied. Today I'm very glad and honored to have with me as my guest Paul Barker, who's a partner at Kirkland and Ellis. Paul, welcome to the program.
Thank you so much for having me, Richard.
So, Paul, I want to start by asking you, before you became a partner at Kirkland and are doing what you're doing now, I understand you were a barrister in the UK. Is that right?
That's right. Yeah, I have not taken a linear path to where I am now.
Well, tell me a little bit about that, because as I kind of told you before we did this program, I haven't come across anyone who's a barrister, at least partners, law firms I talk with. So I'd love to hear a little bit more about that and what exactly does that mean.
Yeah, absolutely. Well, it's a rarity out on the West Coast, that's for sure. And the UK is still, or England in particular, is one of the last remaining jurisdictions that has this distinction between lawyers who work at law firms predominantly on transactions and then advocates who appear in court, barristers. So it still exists to varying degrees in Hong Kong and Singapore, Australia. But yeah, it's not a concept that's very familiar to folks out here. And essentially, barristers are courtroom advocates in the main. They specialize in courtroom advocacy. And also, in addition to advocacy, there tends to be a subject matter specialism that comes along with it too. So it's a little more specialized than general practice as a solicitor in England. But there are the boundaries between the two professions, the solicitor profession, the folks who work in law firms, and barristers, the folks who appear in court. The boundaries are beginning to blur somewhat, but there's still a highly regarded commercial bar in England and in London where barristers focus on commercial disputes in particular, and that's an area where the UK has distinguished itself. And a lot of UK-based barristers, London-based barristers, travel around the world and conduct advocacy and arbitrations in Asia and elsewhere in Europe in international arbitrations, and that indeed is something that I did. So there's a wide range of work that people do as barristers, everything from criminal law through to public law and commercial law. But the world that I was in was focused more on international investment related disputes, energy related disputes, and that was fun because it took me all over the place. So I wasn't just stuck in London, but it's a very different system structurally. So as a barrister, you're self-employed. So you get called to the bar after basically taking a course in London at one of the old Inns of Court, and after that the real challenge is getting tenancy, which is membership of a barrister's chambers, and that doesn't mean you're technically employed by the chambers. In fact, you are effectively working for yourself. You're not sharing profits with other members of the chambers. Yes, you will potentially work with them on matters, but unlike in a law firm, you're independent of your colleagues at chambers. And also, interestingly, it has a concept of tenure. So once you've done typically a year of training, what's called pupillage as a barrister, if you're taken on by your chambers, then that is a long-term relationship you have, and the onus is often on you to go out and develop your practice. Although if you pick the right chambers, you will be surrounded by colleagues with similar interests to you, and so with any luck you'll get to work with other barristers within your chambers. But you really have freedom and flexibility to build the practice as you see fit, and that was something that really appealed to me, and how I was able actually to initially take steps over to the US, doing some work more on the academic side at Stanford, because I had the freedom to account for my time, to take on cases and to take on work in Asia, in Europe, and then also to spend time in the US and focus on academic work, which intersected what I was doing in practice on investment and finance and energy transition, which is what eventually led me down the path to climate and ESG practice full time.
So when you're a barrister, you're doing both in the US what we call trial work and appellate work, or is it you're doing both kind of work? Is that right, as a barrister?
Yes, so it depends on what your area of specialism is. So because I was specialized in investment arbitration and international investment law, a lot of my work was completely detached from the English courts and from courts generally. And so I was appearing in tribunals around the world in the UK, in Asia, in Europe, and in the US. So there is a very international element to being an English barrister if you're practicing one of these areas like international arbitration, international finance, investment, and energy, and so forth.
Got it. So, I mean, would you say the closest concept we have that in the U.S. is something like, you know, how there's these like Supreme Court Supreme Court specialists, you know, they only argue Supreme Court cases. They're often solo practitioners. Is that kind of sort of like what a barrister is a little bit?
At the top level, so there's a hierarchy at the English bar, which is what the term we use to describe lawyers who practice as barristers. And you have junior barristers, and then we have what up until the other week were called Queen's Counsel, and now are called King's Counsel. And they are senior barristers who are selected by an independent panel and assessed on the basis of their advocacy skills and other abilities. And they are then selected for the senior rank of now KC, formerly QC. And many of those develop appellate specialisms, and they will be there is an equivalence to the types of appellate lawyers that you're thinking of here, who have very substantial Supreme Court practices and who argue the biggest cases of public importance, constitutional cases, commercial cases. So there's a slight similarity there, but structurally it is quite different.
So then, since you have to be whatever qualified by the chambers or whatever, when you work as a barrister, then the opposing counsel are always generally people you know or frequently see, I'm assuming, because it's the same set of barristers that get hired by clients or whatever. Is that true?
It's a smaller community. I mean, I think we all know that within our respective realms in law and areas of focus, that the community always feels relatively small. But yeah, with the English bar, just because there are fewer in number, you typically are familiar with the folks that you're either appearing against or working with. And it is despite the fact you're self-employed and you are in some respects on your own, and it's to succeed or fail on your own merits, there is a collegiality there, and camaraderie, which is very nice, and which I think is one of the appeals. I mean, it's a job that people love and is unique to these few jurisdictions of the world, including England, and I think will likely continue in some form, certainly on the commercial side, because it offers specialism, and it's attractive to both the lawyer who wants to perform the role, but also to the client, because they get access to something that they wouldn't necessarily get through a law firm.
So other than the fact that you're independent, I mean, you're really like a trial lawyer in the U.S., right? You're basically trying cases all the time. I mean, is that more as the life of a barrister? It's the equivalent of a trial lawyer?
Yeah, mostly. And with the barristers who focus more on commercial cases and international arbitration, there's obviously quite a lot of work on the papers. So there are barristers who will be in court every day, and at the criminal bar, criminal barristers like public defenders here or prosecutors here are in court far more frequently than commercial litigators. Sure. So there is that distinction, and I did a lot of work, advisory work, and work on the papers. I was not in court every day, but I have colleagues and friends who they would be taking trains around the UK, going to local courts to work on their cases, and they loved it. And a very different world from international arbitration, obviously, but one of the unique features of the English bar is that as a junior barrister, you can get to do these kind of smaller cases and cut your teeth in court and get lots of trial experience and advocacy experience before progressing to the major commercial cases. And that's always been the challenge with law firm litigation practices, of course, is how to get the juniors on their feet, getting advocacy experience.
Right. Well, as if your barrister background were interesting enough in and of itself, you've now transitioned into a very interesting climate ESG kind of practice at Kirkland. So I want to talk about that. Tell me a little bit how you kind of alluded how you transitioned from being essentially a litigator, trial lawyer, arbitration specialist to this advisory practice. Tell me a little bit about the path to get there.
Yeah, it's around 7 or so years ago now. I initially, when I started out in my career, between law, but I was weighing up being between law and being a diplomat or something like that. I always wanted to work internationally, and when I decided to become a lawyer, I gravitated towards those areas that were most international. So it was the international finance, foreign direct investment, energy. And I worked on a number of large energy disputes over the years, and then started, as I say, around the time of the Paris Agreement, around 2015, working on renewable energy related disputes, including cases that involved big policy issues regarding the energy transition and policy support for renewables. And that, to me, was really where my interests most clearly lie, this intersection between business and policy. And so I got, as well as working on this as a practical matter as a lawyer, I was very interested in understanding how private investment could be incentivized to help the energy transition, because around that time, 2015, with the Paris Agreement, there was an increasing understanding that really addressing climate change is about energy transition fundamentally. It's about energy, it's about finance. And I'd been working in this esoteric world of international investment law, dealing with disputes between foreign investors and governments, often concerning energy. And my initial focus really was on the nexus between that esoteric world of investment treaty arbitration and investment treaty protection and energy transition investment, and how the two related, and what governments could be doing, how the law could be better designed in order to incentivize the trillions of dollars a year of renewable energy investment, of clean energy investment, of transition investment that's going to be necessary to achieve net zero and other climate-related targets. So that's where these ideas started to fall into place. But I remained practicing primarily as a litigator, doing more advisory related to sustainable finance, which of course is very closely linked with energy transition and the need to support all of this capital that's necessary. And I got an appointment at Stanford. I was doing a little bit of teaching, and there was a sudden acceleration, I think, over just before the pandemic, but particularly at the start of the pandemic, where climate and ESG issues more broadly really just swept into the mainstream. So not only was it climate with the Paris Agreement and the popular understanding of net zero and the transitions that were underway, but of course there was Black Lives Matter protests, there was the pandemic, and now we have we're now into a new crisis with the invasion of Ukraine and the energy crisis. But there was a sudden acceleration that impacted my trajectory, because all of a sudden I had clients and others who were asking for advice on climate and what was increasingly by then being called ESG legal issues, and that was the trend that I'm not sure everyone saw. There were certainly folks at Kirkland saw it and have been very forward-thinking on ESG, but the reality is the concept's been around for 20 odd years, the idea of environmental, social and governance factors, risks and opportunities, and they've always been there. They're not new, but this terminology really became more significant only in the past few years, and we saw the rise after the Paris Agreement focus on climate-related financial disclosures. We saw the rise of sustainable finance regulation in Europe. And the fact that I was a European, I think, in the US, or bridging the two, and with experience in Asia, meant that I had a pretty unique perspective on the trends that were beginning to take shape. And it was I think it was around it was during the pandemic in 2021 that I heard about Kirkland's practice, and which had been set up by Alex Farmer in Washington DC, who really was ahead of the curve and realizing the importance of having a dedicated ESG practice integrated with all the other core practices of the firm, everything from corporate M&A, finance, capital markets, through to enforcement and regulation and enforcement litigation, and ultimately it was just an incredible, I thought it was an incredible opportunity to focus on what is a really important issue for clients, and something that has shifted from being in the periphery to now being very much front and center for corporates, for clients, for businesses across the board, and very much a legal function as everyone becomes increasingly aware of the risks involved with making commitments and the like. But so the trend's been there a long time, the threads that led here, but there was a real acceleration in the past few years, and I think we're seeing increased sophistication now, and that's why, at our practice here, we have close to 20 lawyers who have a big picture overview of ESG, broadly conceived, but of course within that there's a range of specialisms and real depth, and that's why I have within the ESG, I obviously have a great focus on E and climate. I have colleagues who are focused more on DEI or business and human rights, and so we together we're able to cover what is potentially just this vast realm of issues under ESG.
So tell me, give me an example of the kinds of questions that clients will ask you or that you advise on. Give me a little feel for what exactly kind of advice or issues come up in your practice.
So in the context of climate, it's incredibly broad potentially. So we have our general corporate strategic advisory will include issues around climate commitments, net zero targets, and how to integrate the legal advice with the technical work that has to be done on, for example, measuring greenhouse gas emissions. We're advising on market trends, regulatory trends, litigation risk, in order to help corporates craft their climate strategy, consider how they're going to achieve emissions reductions, for example, whether they're going to set targets, the role potentially of the carbon markets in their strategy. So that's one discrete area, but of course it is incredibly complex and involves technical issues like greenhouse gas accounting. But there's a raft of other areas. Sustainable finance is a big focus of ours, so we're pretty well integrated these days with our debt finance colleagues on the finance front, because increasingly in the US, Europe's led the way, but now here we're seeing sustainability-linked finance, and the fundamentals, of a credit agreement, we plug in with our debt finance colleagues who are experts on this, but there's a new layer of complexity because these loans link the economic incentives under the loan to the achievement of certain key performance indicators, which are essentially ESG related metrics and targets. And of course, our role as the ESG team at Kirkland is to come in and provide expert counsel on that. So, those are a couple of examples, but there are many others. We're doing some very interesting carbon markets work. We work because, as you know, Kirkland is a very large investment funds practice. We work on a number of impact-focused funds, climate-focused funds, carbon markets, and then ESG generally and climate specifically is it's an evolving field, and regulation is rapidly evolving. So of course we are very closely plugged in with our regulatory colleagues and with our investigations and litigation colleagues to make sure that our ESG expertise, and in my case the climate focus, is plugged in across the board with all practice areas, because that ultimately is what Kirkland I think has achieved and set out to achieve, was to ensure that ESG considerations are integrated, because the legal risks and the reputational risks around them are so clear now.
How much do you have to really get in? I mean, don't you have to get quite a bit into the science and the technical knowledge of, greenhouse gases and how that works and the emissions? I mean, if you're reading all the statistics, it can't just be, gobbledygook, right? I mean, you got to really understand that. Tell me a little bit about your knowledge of that area.
So I started, again, this is about 6 or so years ago, was my first exposure to the greenhouse gas protocol, and understand, because it is fundamental, when it comes to addressing climate and addressing any ESG related issues, really, it's measurement's critical. What gets measured gets managed, and it's about lining up the legal aspect with the technical accounting aspect, in this case greenhouse gas emissions inventorying. So I personally have been in the weeds on that a long time, and now we're beginning to see more guidance coming out, fortunately tailored to specific sectors. So increasingly now we have greenhouse gas accounting guidance for the private equity sector. We're seeing it for other areas as well. And we work closely with technical consulting experts who are helping our clients get their arms around greenhouse gas emissions. Some are just at the start of the journey to understanding what their carbon footprint is. Others are far further down the path and are having to comply with regulations in other parts of the world, and potentially in the US very soon too. So we counsel a broad range of clients at different stages of understanding, and really we're never going to be plugging numbers into the Excel, but it's important to be able to sit down with the clients, sit down with the consultants, go through the methodology, make sure disclosures are clear, there's transparency, there's complete understanding in what's being presented, both internally and externally. So yes, there's a lot of technical work, and I think it will only increase, because at the moment there's still a limited amount of data, particularly when it comes to greenhouse gas emissions. But over time, because in Europe and potentially over here in the US too, we're seeing increased regulation requiring corporates to make disclosure of their greenhouse gas emissions, we're going to build up a more accurate picture, and over time that will lead to the ability to make more accurate calculations and increase complexity. I think at the moment we're definitely at a challenging phase, and part of our role is helping clients navigate this, that they do not have perfect information. There are big gaps in the data when it comes to greenhouse gas emissions. There are data quality issues. Oftentimes, when it comes to value chain emissions, businesses are having to use data to make the best estimates they can. But over time, I think this will improve the data quality, and our role will remain plugging in the technical side with the legal and regulatory side too.
Are you still teaching at Stanford or not anymore?
Not at the moment. But I will be doing. I'm going to be teaching some classes at Stanford and Columbia, I think next year, work permitting. Focused on. I've done a couple of classes recently on international investments and the energy transition, and I'm going to do a little bit more focused on climate specifically, and not just climate law and policy, but also bring in these kind of technical issues that you're talking about, greenhouse gas accounting and the like.
Do you see yourself writing a book or anything about this topic?
If I had time, I think it would be. I think at the moment we're in a period where there's a lot of change, and And there's no authoritative definition of ESG, for example. There's still these discussions going on about the difference between ESG integration and investing for impact. There's still nuance when it comes to the energy transition and precisely how that's going to play out. But I think the secular trends are beginning to emerge, and the legal principles are beginning to emerge. So I think a book covering the legal principles underpinning energy transition and the role of corporates in managing the risks and opportunity of climate change. I think that's the right for discussion. So yeah, if I get a few minutes here and there, maybe.
Well, Paul, it's been a fascinating conversation. I really appreciate your taking the time. You've got two very interesting things: your background as a barrister, your climate practice, and if you do decide to write that book, you'll have to come back and tell me about it.
Fantastic. Well, thank you so much for having me, and it's great to be a Brit here on the West Coast and feeling very well integrated into the community. So thanks very much.
This is Richard Hsu and Paul Barker. Thanks.